Good morning, everyone, and welcome to episode 13 of our on-site construction webinar series. This webinar is comprised of 4 bite-sized updates, bringing you up to date on the latest key legal developments. There will also be an opportunity to ask questions of the panelists at the conclusion of the webinar. Today, we are delighted to welcome external panelists, Dr. Sean Brady, of Brady Heywood, an Australian-based firm specialising in forensic engineering, policy advisory, and organisational reliability. So without further ado, I'd like to hand over to Sean.
Hello, everyone. Good morning. I'm just going to share my screen before we start. There we go. Yes, as was said, my name is Sean Brady. I'm a forensic engineer. I investigate failures from an organisational and a technical perspective. And today we're going to talk about the Piper Alpha disaster, which many of you will be familiar with, because it gives us an opportunity to re-examine how we think big failures happen and re-examine how we should think about the prevention of these big failures. So this story begins on the 6th of July, 1988, on the Piper Alpha rig in the North Sea. There's 226 people on this rig that night. The rig first went into production in 1976, and at the time its job was to pump oil onshore in Scotland. But 3 years later, it was upgraded to also pump gas and process gas. And it sent that gas to another platform, MCP01, which then went to Aberdeen. Not only did it process its own gas, it also received gas from another platform called the Tartan platform 12 miles away, as well as the Claymore platform 22 miles away. So it was really the junction where all that gas made its way to MCP01. We're interested in the 6th of July at 9:45 p.m. because at 9:45 p.m. a condensate pump, and this is a pump that pumps a mixture of oil and gas to the rig, this pump stopped working. This was a problem because essentially we'd cut off the feed of condensate to the rig, and it would start to shut itself down within 20 minutes, or 30 minutes. So it was really important for those in the control room to get condensate flowing again. They couldn't get the pump restarted, but they decided that they would use the parallel pump, Pump A. The problem with Pump A, however, was that it was isolated. There was a permit raised to do some work on this pump. The work hadn't actually been started, but it had been electrically isolated in preparation for that work. The controllers in the control room decided what they'd do to get condensate flowing again was that they'd get some signatures on their permit to work form. They would reverse the isolations on the pump, and they'd bring Pump A into service, and that would take over the job of pumping from Pump B. They pretty much put this plan into action at 10 p.m. They removed the isolations, they started the pump, and when they did, almost immediately, gas alarms went off across the plant, and there was a massive explosion that ripped through a whole level of the rig and destroyed the control room. The controllers survived, and the first thing they did was they hit the emergency shutdown. This is incredibly important to do because remember, we've got these other 2 platforms, the Tartan and the Claymore platform, which are pumping gas into the Piper Alpha. And by doing the emergency shutdown, you close the valves at the platform level to stop that gas flowing into Piper Alpha, because of course, if that gas continues to flow, you'll continue to fuel this fire that they're dealing with at the time. And this fire has been burning now from 10 till 10:18. And at 10:18, things get really bad. We have a massive explosion. This is an explosion that essentially seals the fate of the rig for the night. 167 people will die before this night is out. So what happened? Well, remember we talked about these pumps, pump B and pump A. There's a little more to these pumps. Because these pumps are pumping condensate, which is this mixture of oil and gas, you can get pressure spikes inside the pumps. So to deal with that, we end up with a pressure release valve. For pump B, it's PSV 505. What happens is if you get the pressure spike, this valve operates, it collects the gas, sends it back into the system, relieves the pressure inside the pump. And we have also one of these on pump A, which is PSV 504. So at 9:45 that night, the setup looked like this. Pump B was working just fine until it tripped and stopped working. And of course, we said the plan was that the men would reverse the isolations on pump A and bring that back into service. Now, we've got to be careful bringing things in and out of service in a complex system like an oil rig, and that's why we've got a permit to work system. If you want to take a piece of equipment out, you have to raise a permit. It sits in the control room so that you can see what pieces of equipment are in and out of service. As we know, one of the controllers grabbed the permit for the pump because they saw the isolation tags. They saw that no work had actually started on this pump. And what they decided to do was let's bring the pump back into service by reversing the isolations. You've heard all that before. What you haven't heard before is it would turn out there was an additional permit. This permit was on PSV 504, the valve. This permit wasn't stored where it should have been. We believe it was left on somebody's desk. That meant the operators didn't know that there was a permit raised on this pressure valve 504. What had happened that day was work had started on that valve to replace that valve. The valve had been removed. They hit 5 p.m. They weren't allowed to do overtime at the time, so they decided to come back tomorrow morning and replace the valve. After all, the pump wasn't in operation. They put some flanges, some small caps essentially, which they bolted finger tight to cover the pipes. That wasn't to hold in any gas. That was to stop contamination of the pipes. And as you know, at 10 p.m., pump A was brought back into operation. Gas flowed up towards where PSV 504 was. The pressure was sufficient to overcome the finger-tight bolts, and we got a gas escape into the plant. This gas escape occurred within one of the modules. This is a plan of Piper Alpha, and we had an ignition source and an explosion. So this is what initiated the event. And it's really easy to sort of say, okay, but really is this a single point of failure? If we want to understand what caused this incident, do we simply blame essentially a failure of the permit to work system? Well, we don't. And there's a really useful analogy to help us change how we think about failure in complex systems. And that, of all things, is the game of Jenga. You've all played Jenga where you pull blocks out and put them on top until the flower falls. Now, why does Jenga help us understand how these failures happen? Well, we try to prevent failures and manage risk by putting in some sort of a system. In other words, we put in a rock solid Jenga tower to manage our risk. And we tend to assume that this tower is going to remain rock solid and work as expected. But in reality, what happens over time is our system that we've designed so carefully to manage our risk starts to look like this. It's full of holes and it starts to deteriorate. The important thing is, although it's full of holes, nothing bad has happened yet. The system looks like it's performing just fine until this sort of thing happens. And when this happens and we collapse our tower or our system, we have a nasty habit of going, there's the person. They're the person who is to blame for the system failing. If they hadn't removed the block, the tower wouldn't have failed. If the permit to work system had worked, we wouldn't have had the Piper Alpha disaster. But of course, the tower didn't fail because the block was pulled. The tower failed because it had been inherently weakened over time by the removal of other blocks. And the removal of the last block was merely the initiating event that took place. And we see this in almost every major failure. Systems that organizations designed to manage risk look great. We assume they're great, but they're actually full of holes. And it's usually only after the tower falls that these holes become apparent to people. So with that in mind, let's look at the holes, or some of the holes we had in Piper Alpha. We have the initiating event with the permit to work system failing and a piece of equipment brought online when it shouldn't have been. What were the other holes? Well, one of them was the blast walls. And when you're on a platform like this and things are flammable, one of the things they did in the original design was they made sure they put in firewalls. So they compartmentalized the structure. And by doing that, you could contain a fire and get it under control. The problem was when they upgraded Piper Alpha to deal with gas in 1979. And gas is explosive, not just flammable. They never upgraded the firewalls to blast walls. And that meant that when we had our explosion here in Module C, that explosion ripped through the walls, was able to cause extensive damage across that whole level of Piper Alpha, and essentially start a fire that couldn't be stopped. So our key hole in this Jenga tower is a lack of blast walls. The next block that's worth talking about is the failure of the Tartan riser. So remember we said we've got this Tartan platform down here, 12 miles of gas in this pipe going to Piper Alpha. They closed the valves at the Piper Alpha deck level to stop that gas getting up into Piper Alpha. But the problem is because those fires have been burning because the firewalls didn't survive. The heat has become incredible at that deck level, and what has happened is we have basically got steel that is losing its ability to restrain that gas, and it fails. And because of that, we get the massive explosion as this gas from the Tartan platform is now fueling Piper Alpha like a blowtorch. At this point, there really is no survival of this platform at all. This is made worse half an hour later by the failure of the riser from MCP01. We're pumping the gas to MCP01, but of course what has happened here now is for the same reason the heat in Piper Alpha itself has caused the riser to fail, and we now have an explosion that's 3 times bigger than even this. And this leads to the collapse of the Piper Alpha structure basically within the next sort of half an hour. Now, you might be saying, Sean, yeah, this is great with the benefit of hindsight. How do you see these holes? How could we possibly know these holes were in our system? Well, what we find in most investigations is that the evidence of the holes was there. In this case, it was a report from 2 years earlier in 1986, and this report acknowledged that fundamentally a major hazard was the lack of subsea valves. You couldn't turn off that gas at sea level, you had to turn it off at platform level, which made the platform more vulnerable. There was an acknowledgement this is going to cost a lot of money and it's probably not worth doing. But even though they said they weren't going to do it, there was an acknowledgement that a high pressure gas fire, which is exactly what they got, would lead to a virtually impossible fire to fight, which is actually what happened. Taking a systems approach to the management of your major hazards is accepting that you want to manage these high consequence, low likelihood events by building the perfect Jenga tower to manage that risk. But when we really think about what causes these failures, it's really all about knowing that you will get holes in that system. And your job, if you want to prevent major incidents, is to identify where those holes are and plug them before the disaster happens. Thank you very much.
Thank you very much for that, Sean. My name's Ryland. I'm a partner at Watson Farley in the disputes team, and I'm going to be trying to cover AI and the future of dispute resolution in the short time that we have. So the topics I'd like to cover are as follows. First of all, I'm going to be looking at the legal position under English law. I'll then be talking about an event that we hosted recently in relation to AI, and one of the first systems in the world, the American Arbitration Association, have adopted an AI arbitrator system, and we were very, very lucky to host the lady who came up with the idea at that event. So I'll tell you a little bit about that. We'll talk about what the two panels were discussing at the event, both from perspective of the risks and governance, and then secondarily the opportunities for AI. And then finally, we'll jump to questions at the end. So starting with the legal position firstly, the position under English law is obviously unfolding before our eyes because this is a new area. But the starting point is that AI is considered a tool or an instrument. Therefore, there's no agency and there's no independent liability for the AI system. In other words, it's the responsibility of the lawyer or the individual using the AI system to ensure that it produces correct results. It's not governed as yet by central statute or laws, specific statute, and it's being dealt with through case law that's being decided through the courts. But the perspective of that case law is very much about governance. So if we're talking about lawyers through the process of dispute resolution, that would be a question of governance by their regulating bodies, so the SRA or the bar standards obligations that they have to clients. I think a golden rule and using it on matters is to ensure that you inform clients from the outset to what extent AI will be used. And law firms are now looking to incorporate wording within their terms of business and at least being upfront with clients and being transparent about how it's going to be used. A couple of tales from the courts recently really focus a light on this. First of all, Sullivan and Cromwell is an American case where an American law firm was exposed for using or over relying upon AI within a bankruptcy motion. And apparently there were 42 errors within the court submitted documents. And there were sanctions for the law firm, including damages and breach of standards for the individuals involved as well as the firm. There are more and more cases in the English courts. Al Haroun is one of the most high profile, where there was a claim for £89 million against the state of Qatar, and there were 45 incorrect case citations. 18 of those did not exist at all, and hence the phrase hallucination is becoming more common. What were the consequences? Well, the case failed, but secondarily, there was a referral of the solicitor to the SRA, and the High Court warned that this could lead to contempt of court proceedings. And there are more cases. There was a recent case in May involving Pinsent Masons in a case of Cork versus Smith, where again there was an over-reliance upon AI in the submissions made, and Pinsent Masons ended up having to apologise for the use of that, and there will be consequences in terms of conduct. And they said that they were going to tighten up their systems. So we're all playing catch up really in the disputes world. So this is why I thought it was so interesting to host this event and to talk to the American Arbitration Association about what they're doing. What they've effectively done is they've built an AI arbitrator. Now, what does that mean? Well, essentially, what they've done is they've built a system that can facilitate an arbitrator making a decision more quickly. Now, the good thing about arbitration is that it's not restrained to the same extent as court proceedings are. So it's a natural testing ground for AI. How should it be used? Well, what they talk about is human in the loop. For those of you that don't know, that means that you use the system to take you to certain stages in the process, and then the human effectively signs off those stages. What does it do? Well, there's no doubt it can save time, which effectively should mean that things are quicker, it's more consistent, and the costs are still split between the parties, but they're indicating that are at least 30 to 40% cheaper than ordinary arbitration proceedings. I think the key point is how do we ensure that it is a safe and reliable system? The keynote speaker was Bridget McCormack, a former Supreme Court Justice, and she spearheaded this process. I will say that I myself gave a keynote speech, albeit with a small k, before Bridget McCormack. There were two things that I mentioned in my speech. The first thing was about access to justice, and this was echoed by Bridget McCormack. But in the UK, for example, according to the Bar Council, 36% of civil cases involve a litigant in person. So there's a big question there about access to justice. And I do believe that the AI has an important role to play in that space. And the second is about energy. And very few people talk about energy consumption. But let me put it this way. According to ChatGPT, 2.5 billion requests are made each day. Now, I was trying to work out how many of those requests relate to people simply saying thank you. And it turns out that about 1 to 5% of those requests involved a thank you. And what that means by my calculations, checked by ChatGPT, I should caveat, is effectively we're talking about 25 million requests a day, 8.5 megawatt hours per day. And overall, what we're talking about is on average, a 25 megawatt hours per day in total energy usage, which is the same as powering 800 houses in the UK. Now, of course, those numbers can be manipulated, but that's, I think, a key thing to consider in all of this. One of the key things that Bridget McCormack mentioned was that the AI will be embedded in the ecosystem of dispute resolution by way of use by judges, courts, and lawyers. But what she did caution against is deepfakes, and that's not just pictures that are edited with different faces, if you're familiar with those. It's about fake documents. And this is something that it is a deep concern because, even these systems can be tricked. And so I think, while we start to adopt more technology, we're also going to have to make sure that there are safety measures in place to ensure we can check the validity and authenticity of documents. So how does the AAA system work? Well, effectively, it's an opt-in system. There's a human in the loop, as I mentioned. So effectively, the decision and each stage of it is signed off by an arbitrator. A summary is prepared for the arbitrator. It gets checked. And the idea is that the process then narrows the scope of the decision. Through time, it was suggested that we'd have AI agents for each process. That means that you have an overall AI system, and then you can have agents within the system that have specific tasks. Effectively, workers running around a factory, for example. Um, the system works great where you have an agreed set of facts. The truth is that the system is limited in terms of making value judgments. And I think that's one area where humans will remain certainly important for the time being, at least. And I mentioned that costs are split between the parties. So very briefly then, what do the two panels make of this? There's no better way to test a system than to ask the experts. And by the way, these were panels made up of industry experts across the world. Panel one was talking about risks, and what they were saying is that there's no consensus across the board effectively as to whether AI should be used at all. There was a certain degree of skepticism around whether it should be used at all in legal decision making. The main concern was that there was a lack of empathy in the system. There was reference to the Horizon IT scandal. One of the key questions is whether the burden of proof should be shifted for parties to prove that their system is adequate. And I think that's something we'll see certainly will unfold. The big mistake in that case, among other things, was that the court or the tribunal and the prosecutors were relying upon the fact that the Horizon system was accurate when in fact it wasn't. The second panel was talking about the opportunities, and these are huge. Certainly, the opportunities for good business practices, for streamlining processes. Um, the reality is that disputes don't start in a tribunal. Disputes start way before that, before even any shovel is chucked into the ground on a building site. They start with the contract formation, they start with the administration, and that's where AI and records created by AI can become very useful. Will lawyers be required in the future? I'm afraid the answer is yes. The truth is that these systems can't operate alone. They are tools. We need the professional standards in place, and these need to be checked by lawyers at each stage. And the technology will improve. The time for processing disputes will come down, and ultimately the cost will come down. So using AI as a tool and not as a lawyer in itself is I think the answer. There are plenty of opportunities and there are also plenty of risks. But I think, if any profession can make this work, it is ours. So on that note, I will hand over to Stephanie for the next session. Thank you.
Thank you, Ryland. Good morning, everyone. Thank you all for attending today. By way of introduction, my name is Stephanie Giesing. I am counsel in the dispute resolution team here at Watson Farley and Williams, based out of our London office. I specialise in construction disputes across the infrastructure and energy sectors, both on a national and international level. So you can see on the slide here that today we're going to look at retention. So in particular, I will be discussing the government's recent proposal to abolish retentions in construction contracts. This proposal was first announced in March 2026 as part of a wider package of late payment reforms. On the 19th of May, the government introduced the Commercial Payments Bill into Parliament. The bill follows a period of consultation on government proposals to address late payments across the industry. Interestingly, it has been referred to as the Small Business Protections Bill. So this gives a good indication of the intention behind these proposals. However, while the intention is positive, the commercial reality is more nuanced and the consequences may not be as straightforward as they appear. So while the bill is in its early stages and could still change, it is important that the supply chain start thinking about how it may want to manage risk if retention is no longer an option. As you will be aware, the current practice of retention is deeply embedded in construction contracts and projects. It can be found in both the standard forms, such as the JCT and the NEC, and also remains in bespoke or heavily amended contracts. From a practical perspective, it usually operates by allowing the employer or contractor to withhold a small percentage, typically 3 to 5%, from interim or milestone payments. Half of this is often released back at practical completion, while the rest is withheld to the ends of the defects liability period, which is usually 12 to 24 months after practical completion, depending on the project. Retention generally serves two simple but important commercial functions: to incentivize contractors and subcontractors to improve performance, and to provide security for defect remediation and insolvency down the supply chain. However, retentions can be problematic. They are often delayed, only partly released, or lost in insolvency, which can directly impact contractors by reducing their working capital and investment funds. The consequences of this are particularly severe in the construction industry, where cash flow can be problematic and the profit margins are already incredibly tight. The idea of reforming retentions in construction is therefore not new. The government has previously reviewed construction retentions back in 2017 and more recently in 2020. So there have been various attempts to legislate on this over the last few years. However, if we look at the proposal now, it looks like the government is committed to actioning change following the press release. So on the 24th of March, as I mentioned, the Department for Business and Trade published a package of late payment reforms, including a proposal to ban the practice of deducting and withholding retention payments under the terms of a construction contract. The government consulted on two legislative options. Number one, a complete prohibition on retention clauses, and number two, permitting retention clauses subject to a protection mechanism for the benefit of the payee. The government seems to prefer an outright ban, citing simplicity and lower implementation costs. In introducing the proposal, the government has brought its focus on addressing the payment and cash flow risks that retentions may present. Specifically, the stated objectives are to prevent companies, particularly SMEs, from the loss of retention sums through insolvency and late or non-payment. One example that is often discussed in this context is the impact that Carillion's insolvency in 2018 had on the supply chain and particularly SMEs, but also to address late payment practices, which are estimated to cost the UK economy around 11 billion annually. This ban is expected to be implemented through amendments to the Housing Grants Construction and Regeneration Act 1996, often just simply referred to as the Construction Act, alongside broader reforms including caps on payment terms and mandatory interest on late payments. The bill suggests that the ban on retentions will come into force in stages, so there will be a transitional period of about 2 years. Then the ban will come into force at the end of that period. Retention clauses agreed or varied during that transition period will remain effective until the last retention day, which is 3 years from the initial commencement of the transitional provisions. Although this seems to be quite a lengthy transition, you can still imagine a situation where we have lengthy projects that could get delayed. So this is something that the industry is definitely starting to think about now. So the next question we want to look at is, does this solve the real problem? In considering the potential effectiveness of abolishing retention, and to answer the question, does this solve the real problem, it is helpful to revisit the commercial operation of retention. So on the employer side, retentions provide immediate liquidity without the procedural hurdles associated with calling bonds or guarantees. They provide a readily accessible fund if defects are not remedied and encourages contractors to return during the defects liability period. As I already mentioned, this period is typically 1 to 2 years. It's relatively short and closely aligned with the period in which defects are most likely to materialize. On the contractor side, retentions are treated as anticipated deferral rather than lost cash, and contractors already price retentions into their cash flow planning. As such, rather than functioning as an external security arrangement that distorts financial performance, retentions are absorbed into the operational planning in the same way as other contingent project costs. Removing retention also risks creating a situation where a contractor has been paid in full, even though it has not completed all of its obligations, particularly in respect of defects. So arguably, retentions are not simply a disruptive burden. The fact that they are already built into commercial models makes it much harder to argue that abolishing them altogether will proportionally eliminate the risks associated with delay, non-release, or exposure to insolvency. Some might argue that it simply shifts these risks into other potentially more costly or complex forms of security. So we ask, what next? If retentions are prohibited, such risk will not be removed, but will need to be managed differently. So the first thing we look at is bonds and guarantees. So to compensate, employers may require performance bonds, on-demand guarantees, or defects retention bonds. These instruments add cost to projects and may not be available to everyone. There will therefore have to be further consultation and work done with the government and the insurance market to come up with some creative solutions or making these instruments that already exist more accessible to SMEs. In any event, it is likely to increase cost and complexity and lead to more upfront administration and costs as well. You can also consider positive incentives, so a bonus for defect-free completion following the defects liability period. The logic here is behavioral rather than protective, so instead of securing performance through withheld funds, the contract will seek to encourage it through reward. However, again, this is unlikely to reduce costs. Any bonus can be expected to be priced into the contract sum, meaning the contractor ultimately funds it. This may change how performance is incentivized, but does not necessarily change the economic position. There's also been some discussion as to whether you simply restructure payment provisions. So this might be the most straightforward workaround. In particular, we're thinking about a deferred final payment payable at the end of the defects liability period. Commercially, this produces the same result as retention, and therefore whether this will still be effective will need to be seen. The difference here is that the employer must make a positive payment later, which may reduce leverage and change the dispute dynamics as well. One of the potential risks that this would resolve is the incentive for the contractor to return to site to rectify defects. There's also some discussions around project bank accounts and escrow. So this could also be used. It might help with the insolvency risk and incentivizing contractors to attend to defects, but project bank accounts are not widely used across the industry in all areas because of the additional costs and administration to set up and operate. Escrow could be another option, but again, there are additional costs and administration associated with that as well. So in addition to the various instruments or mechanisms that might take the place of the current retention process, we can also expect increased scrutiny of subcontractors generally, so the tightening of pre-qualification checks, which may also have an impact on the procurement process. So just to conclude and look moving forward, retentions remain commercially difficult to replace. Although the current system is not without its problems, I think that's widely accepted. Some might argue that this mechanism still provides a proportionate, time-limited, and operationally straightforward way of managing post-completion risk. The issues we most often see, delayed release or exposure to insolvency, stem more from how retentions are administered than from the mechanism itself. Targeted improvements such as greater transparency, safeguarding funds through escrow, and enforcing timely release could address those concerns without needing to discard a mechanism that continues to perform a clear and practical function. Some of the alternatives that are currently being considered are likely to have other cost and time impacts on the supply chain and also negatively impact SMEs. There is, of course, that risk that alternative form of security will not be available. And in that case, employers and main contractors might insist on lower contract prices to compensate for this loss, or in consideration of more risk being taken up the chain. Therefore, the financial pressure that retention causes is arguably not eliminated by these proposals. It might simply be redistributed across the supply chain and felt at different times in the project. While it may all still be some time until this takes effect, and obviously things can still change, parties to present and upcoming construction contracts should start considering how to best manage risks should retention not be an option. Consideration should be given to the likely additional costs of alternative security arrangements as part of the overall commercial project landscape, and most importantly, how timely rectification of defects will be managed without a retention mechanism. The government has already suggested that it is alive to some of the issues that abolishing retention may create, and ultimately this will need to be balanced against the very reasonable objectives that it has set. We understand the government will work with the Small Business Commissioner and Construction Leadership Council to produce further guidance, which it is hoped will cover some of the issues discussed today. But I'll leave you with a very simple watch this space. And I will now hand over to Barry.
Thanks very much, Steph. So in our final presentation this morning, we're going to look at the new building safety levy. So this is a construction tax being introduced by the government to residential property developers. And the tax is intended to contribute to the government's investment in building safety and to protect residents from unaffordable remediation costs. The aim is to raise about 3.4 billion over 10 years, and developers building new residential dwellings or purpose-built student accommodation will be responsible for paying the tax. In terms of the background, the Building Safety Act permits the government to introduce a tax on applications for building control approval. We now have details of how the tax will work in practice. They were published last November, and it's going to be a tax payable as part of the building control process that will apply to all new residential developments unless excluded. So as briefly mentioned, it's going to come into force from the 1st of October 2026. It will not apply to building control applications made before the October deadline, even if works start later. Local authorities will be the relevant tax collection entities responsible for collecting the tax on the building control applications, and they will work with building control to identify the amount payable. So essentially what happens is that where there's a development that creates or increases residential floor space, which either taken together or on its own results in at least a development of 10 dwellings or 30 bed spaces in purpose-built student accommodation, the tax will be payable. There are certain exemptions from paying the tax, such as non-profit registered providers of social housing and charities, etc. It's likely that there's going to be a short window where developers will seek to submit applications for building control approval before the October deadline. That's fine, but any applications that are brought forward will need to be genuine and sufficiently developed to avoid the risk of abuse or challenge. So in terms of how much will be payable, so this will be assessed by reference to an area rate set by each local authority, and different rates will apply for different local authorities and different types of work. So the highest rate is set by the London Borough of Kensington and Chelsea, and their levy is over £100 per square metre for new residential development. County Durham has the lowest building safety levy. It's set at £12.70 per square metre. For some reason, Macclesfield was on my mind. The Wigan rate is £20.22 metres. And for brownfield developments, the charge is £10.11 per metre squared. So it's basically a tax that's paid on the first completion notice or the first date of occupation. So that means before the project has completed or before occupation, the tax needs to have been paid and evidence of payment needs to be provided. And obviously, any developers will need to be thinking about what the impact that could have on drawdown and completion in the event that the tax is delayed. So we're likely to see confirmation of payment being required at various intervals. And for example, if the amount of the tax is not included in an initial notice, for example, or an amended notice submitted to the council, those notices must be rejected. And the regulations permit the sharing of information between the regulator and the collecting authority to make sure that the correct amount of tax has been paid. And it's likely that there's going to be a certificate issued confirming payment, and that's going to have to be produced at various stages. And any appeals relating to the amount payable can be made to the first tier tribunal. In terms of the position in Scotland, the Building Safety Levy Act was approved by the Scottish Parliament in March. The tax will be payable in Scotland on the conversion or construction of residential property developments. The aim is to raise about 30 million annually, and the amounts raised will be devolved taxes. There are key differences between the English and Scottish position. So in summary, in England, the person responsible for payment is the person carrying out the development. In Scotland, it's the person that's the owner of the building. In Scotland, they have a threshold of 19 units. In England, the allowance is 10 units or 30 student bed paces. And there's a wider list of exemptions in Scotland. So the Scottish tax won't apply to hotels, care homes, etc., etc. So it's a much broader list of exemptions. The timescale for implementation in Scotland has been postponed to the 1st of April 2028. So the idea is that following publication of the indicative tax rates this month, there'll be a 22-month leading period. In terms of the rest of the UK, there's no equivalent of the building safety levy currently in Wales or Northern Ireland. They've not implemented the developer levies established by the Building Safety Act. Wales is relying currently on the equivalent of the Developers Pledge, known as the Developers Pact in Wales, and Northern Ireland receives direct funding for its remediation projects. So there's another point that's just worth considering very briefly as part of our overview of the tax. So for non-higher risk buildings, there are essentially two ways in which you can obtain building regulation approval for those buildings under 18 meters or 7 stories. So these are the buildings that don't require the building safety regulator approval. So for those non-high risk buildings, you can either make an application for building control approval by way of the full plans route. So that's essentially where, as the name suggests, full plans are produced, structural calculations, they're submitted to the local authority, and the local authority takes up to about 5 weeks to review the information before any work start on site, upon which approval is given. So that's the first route. The second route is the building notices route. So what happens there is these lower risk projects can provide information to the council as the works progress, with more information being provided at various intervals. And the key difference between the two methods is that the full plans route is more expensive and slower because you need to produce everything up front. The building notices route is quicker and less expensive because it's a provide information as you go procedure. Now, you'll say, well, what does this have any reference to the building safety levy? The important point is that when the building safety levy legislation was passed, it was only drafted to cover applications under the full plans route. So that means there's a gap in the legislation that means if you apply for building safety approval under the building notices route, currently as the legislation is drafted, the building safety levy isn't payable. The government is consulting on closing that loophole. Various reasons have been suggested as to why the building notices route should be phased out. It's said that it's necessary because of those projects are more likely to breach building regulations. It will improve compliance, reflects the complexity of new dwellings. But you can't help thinking that one of the effects of the proposals would, of course, be to prevent the building notices route being used as a means to avoid the levy. So, in summary, it doesn't make a difference in terms of payment if you use a local authority or private building inspector on non-high risk schemes to obtain building regulation approval. The difference is whether you use the full plans route over the building notices route. And currently, there are more likely to be tax advantageous position in using the building notices route over the full plans route. The consultation closes this week. If anyone's interested, it can be found on the government consultation hub on the .gov.uk website. As part of that consultation, there's another part that you may be interested in, because there's also a consultation about whether the plan certificate route should only apply to home extensions, loft conversions, other structural works to dwellings. So that essentially means that you would need to follow the slower, more expensive route if you're proposing a loft conversion or a home extension, than the quicker and less expensive streamlined procedures. That may be something that others want to have a look in the consultation that covers the position and closes on the 11th of June. So in summary, we have this new tax. It applies from the 1st of October, covers new building and refurbishment projects, applies to residential projects of 10 homes or more or 30 bed spaces in student accommodation. It will be collected by the local authority, who will set the rates from each area. Scotland will operate its own scheme from the 1st of April 2028. The tax doesn't currently apply in Wales or Northern Ireland. So where the tax does apply, expect that proof of payment will be requested and will need to be provided, such as before homes are occupied or before they're sold, and continue to keep under review whether this quicker and cheaper route to obtaining building regulations approval for non-high risk residential projects will be discontinued in order to close out that loophole. So in terms of what developers of residential property or student accommodation can be doing right now, well, first of all, we need to view this tax as part of a wider series of measures that the government has introduced in order to improve building safety. So we've had several reforms, such as the Developers Pledge in England or the Developers Pledge in Wales. And for residential developers, this is another issue that will need to be viewed alongside the Section 106 commitments, the Community Infrastructure Levy, which is levied by local authorities on new developments to help fund local infrastructure like schools or health facilities, and also the affordable housing component. And the impact of these measures will need to be seen and taken into account in the round. Any developers who are thinking of bringing forward applications and submitting applications for building control approval on or before the 30th of September, fine to do that, but ensure the applications are sufficiently developed to avoid the risk of challenge. And it would also be sensible for developers to review their development agreements and their funding structures to consider who bears the cost of the levy. So while the statute is quite clear that the person responsible for payment is the party carrying out the development in England or the owner of the building in Scotland, those obligations might be more nuanced by the parties' commercial agreements. So, for example, in the development agreement or forward funding deal or joint venture agreement, the parties may have agreed between them who will bear the risk of new statutory costs and whether a developer, whether the levy is a developer cost or a recoverable cost. And I think they should also be looking at the timing of payment. It's important for developers to consider that this tax will need to be paid before occupation, and that may have cash flow and financing implications, particularly for those forward funding or phase schemes, and those implications will need to be considered very carefully. Developers should consider whether phase developments should be aggregated for threshold purposes, potentially for bringing smaller phases within scope. It's really important to make sure that the tax is paid on time to avoid the risk of delays and drawdown issues. And if the building notices route still remains available for non-high risk schemes, one needs to consider whether the tax implications for following the building notices route are more advantageous than the full plans route. So very much need to keep all of that under review. So in summary, review your pipeline against the 1st of October deadline, update appraisals and land bids, check contractual risk allocation, monitor the outcome of the building safety reforms. And now I hand back to Rebecca.
Thank you, Barry. Thank you, everyone, for that. I think we've got time, just time for some questions. So I'm just going to take a look at those. Sean, there's actually a dedicated question for you, I see, asking about when the Brady Heywood podcast will return. So
Yeah, this is a question we get asked a lot, Rebecca. So the good news is it's coming back. We're going to change it slightly. Instead of doing monthly episodes, we're going to do series that tackle particular disasters. So we have got one that we're working on at the moment on Piper Alpha, which will be 3 half-hour episodes. We'll release them one a week for 3 weeks. And we've also finished the first draft on about a 5-episode version of the Challenger disaster that we really dig in and pull apart the technical and the organizational causes. So yes, it's coming back, and we're very excited about working on it again. So thank you for the question.
Okay, great. Okay, well, there's a specific question here about retention. So I'll put that to you, Steph.
Yeah.
The question is, can the parties still agree something similar to a retention in their contract?
So that is a good question, because it is, of course, possible to contract out of certain statutory provisions. But as currently envisaged, the proposal is that it will be a statutory prohibition. So you can't contract out of the ban on retentions. That probably, or most definitely, will mean that there will also have to be amendments to the standard forms. So we'll see what happens with that. And I know some of the things that we've been talking about in terms of deferred payments and potential for bonuses and all the rest of it. I mean, those are things that were kind of considered at the outset, but I would say that probably where this is going, that might not be a suitable alternative, because that might still fall foul of the prohibition. But all of that will remain to be seen, to see exactly kind of how it gets drafted. So I suppose the short answer is probably not. You probably cannot kind of contract out of this and still have a retention mechanism. But there has to be a little bit of, we need to wait and see.
Thanks, Steph. Okay, well, we've got an AI question for you, Ryland, which is obviously very topical. So the question is, as AI becomes increasingly capable of predicting case outcomes and even generating settlement proposals, do you think the future role of dispute resolution professionals will be to make decisions or to oversee and legitimize decisions made by AI?
Yeah, okay. So, yeah, I think that's a central question. I mean, the reality is that AI is already becoming extremely effective at analyzing evidence, identifying patterns across, thousands, even millions of prior disputes, estimating litigation risk, and as you say, settlement options or proposing settlement options. There's a whole range of different types of question built into that. I mean, starting from the trivial, you can ask AI questions like, was Pep Guardiola the best football manager of all time? Should Declan Rice be captain of Arsenal? And then you get into more, controversial issues like, should AI be used for the vetting of politicians like Peter Mandelson, or is MAGA working in America? What's the best strategy to open the Strait of Hormuz? Um, I think the reality is that dispute resolution itself is not about predicting outcomes solely. It's about trust. It's about procedural fairness. It's about empathy, legitimacy of the decision maker, and the ability to account for unique human circumstances that may not fit historical data. So I think the future is more about augmenting the decisions. I think that professionals will spend less time on administrative, analytical tasks, and more time exercising judgment, managing relationships, ensuring fairness, and explaining their decisions or the decisions that have been made. The key challenge is to design a system where humans are accountable, but also by benefiting from AI's speed and consistency. So I think the future is certainly will involve lawyers and professionals and humans in the loop.
Great, thank you. Okay, well, we're close up against so I've got a safety levy question. Will the building safety levy have an impact on land bids, and is it expected to be priced in? That's for you, Barry.
Thank you. So I think in the short term, developers won't be able to pass on the cost, particularly for contracted land deals. And the timing of the application around the 1st of October deadline is key. So I think currently schemes in the pipeline must absorb the cost of the tax. But over time, I think the levy is likely to be reflected in land pricing. And we looked earlier at the differences in levies, in different parts of the country. And I think you're likely to see that working through in land values in due course.
Okay, and with 2 minutes to spare, and I don't know whether you'll be able to do this justice, Sean, but this is a biggie. What do you think is one of the biggest flaws in how companies manage some of their major risks? So 2 minutes to grapple with that one.
Yeah, two things. I think many companies still genuinely believe that they can build a perfect Jenga tower to manage their risk. They put it in place, they have superficial means of monitoring whether it's working, and then they're genuinely shocked when they find there's holes in it. And of course, nobody wants to tell the boss that there's holes in their perfect system. That's probably the single biggest issue. The other problem is that whenever we're dealing with low likelihood, high consequence events, we humans love to focus on the fact that it'll almost never happen. So we focus on the low likelihood, and all the industries who've made very big strides in terms of prevention of major incidents dispense with likelihood completely. And they say if the consequence is high enough, we focus on putting controls in place to prevent it, full stop. But that's something that we humans are not normally comfortable doing.
It's a fingers crossed approach, but yeah, that suggestion sounds sensible. Okay, so well, that concludes today's session. I'd just like to thank all of our panelists. I think that was a great webinar, and I hope everybody else found it informative. A feedback form will be circulated later today, and we'd really appreciate any feedback you have, and of course, any topics that you are really keen for us to address. The recording of the webinar will be available on our YouTube channel, and that'll be later this week. And the next on-site webinar will be in Q4 2026. But if you can't wait that long, I've got good news for you, because we wanted to let you know that the Technology and Construction Court, in association with TechBar and TEXA, will be holding an event on the evening of the 14th of July, and that marks the launch of the 4th edition of the new Technology and Construction Court Guide. And a special shout out to Barry because he was one of the members of the drafting committee for the new guide. And so the launch event is being held at WFW. So we'll be circulating invitations for that shortly. But obviously, we would love it if people would attend that, and we'd be delighted to host you. So I just want to wish everybody a very happy remainder of the day, and hopefully see you on either the 14th of July or the next webinar series. Thank you, everyone.